So two of the questions about the courts have to deal with staffing the courts. How do we go about appointing justices? And one of the questions for Chapter 8, who decides how many people are Supreme Court justices, and what is the process for adding or decreasing Supreme Court justices? And then the other question that was related, it was mentioned that judges have lifetime appointment. Is it possible for them to be removed? If so, what does it take, and who declares it? Some really good questions about staffing the courts. So I would again encourage folks, I'm going to start off by going back to the Constitution, our governing document, and first I want to pull your attention to Article 1, Section 8. Again, that squiggly symbol stands for section. You can find it on page A16 in the back of the textbook. In Article 1, Section 8, the Congress shall have power to, and remember it goes through a number of enumerated powers, powers that are expressed, powers that are specifically granted to Congress. And one of those powers to constitute tribunals inferior to the Supreme Court. What does constitute mean? Well, it means to create. And if you create something, you have to staff it. You have to be able to put personnel with it. Go to Article 2, Section 2. And here, that's on page A18 of the Constitution and the textbook in the back. The President, and again, Article 2 deals with the executive branch, so the President has the power, he shall nominate, and by and with the advice and counsel of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States. So members of the court, Supreme Court, are appointed by the President with the advice and counsel of the Senate. That's the Senate confirmation process. And then all other officers of the United States would include any of the tribunals inferior to the Supreme Court, meaning lower level judges. Then finally, Article 3, Section 1, on the next page there, A19 in the back of your textbook. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain. Then you go on to the next particular section. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. What this is basically saying is, if the judges are on their best behavior, are on good behavior, they can be paid a compensation, otherwise known as a salary, which shall not be diminished. It can't be cut during their continuance in office. Members of the court serve for lifetime appointments. They could certainly retire, they can resign. Some judges die while they're in office, but as long as they are in office, their salaries cannot be cut as long as they are on, quote, good behavior. So, in terms of thinking about staffing the courts, we have to look at it in a couple different ways. First, congressional power. What does Congress have in terms of the power of the courts? Well, certainly Congress can create inferior courts to the U.S. Supreme Court, but they can also set the size of the Supreme Court. Currently, we have 9 justices, but Congress can decide to either increase the court's size or, upon retirement or death or a vacancy, decide to decrease the size of the court and the number of justices. There's been some controversy of recent note that perhaps if the Democrats get in control of both the House and the Senate, and there is a Democratic president, they might decide to increase the size of the Supreme Court in retribution for the Republicans holding open one of the seats under Barack Obama and letting President Trump appoint not just one but two new members of the U.S. Supreme Court. They also set the size and the number of the inferior courts and the judges to fill those particular courts. In terms of presidential power, when it comes to staffing the courts, as noted, probably the most important presidential or executive power is to nominate individuals to fill judgeships. Remember, though, it has to go about with the consent of the Senate confirmation process. Now, when it comes to staffing the courts, there is also the question was asked about, can judges be removed? How are they removed? Well, certainly if a judge decides to retire from the bench, that's one way that a vacancy can be created. Sometimes judges die while they're serving on the bench. That's another opportunity. But there is a shared power by Congress to remove both justices and judges. And again, I would point back to Article 2 that deals with the executive branch, but Section 4, there on page A19, right before Article 3, Article 2, Section 4 talks about the President, Vice President, and all civil officers of the United States. So any civil officer, meaning not just members of the cabinet, but also justices and judges, are considered to be civil officers of the United States. They can be removed from office on impeachment. And again, as we saw earlier this semester, we talked about the impeachment process. It follows the same process as the presidential impeachment process. Again, impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Now, in the history of the Republic, we have had 14 federal judges and one Supreme Court justice who have been impeached. Not all of them were convicted or removed. 10 of them were removed. Some of them decided to resign their particular position. A most recent case of a federal district court judge being impeached and removed was a judge by the name of Alcee Hastings. Alcee Hastings was a district court judge in Miami for the Southern District of Florida. Alcee Hastings was impeached and removed from his judgeship. He subsequently ran to be a member of the House of Representatives and was elected. So indeed, if you've been impeached, you can be removed, but you can run for another branch of the federal office if you are a federal judge and be elected to Congress. If you want more information about judges who have been impeached and removed, you can go to this website, the Federal Judiciary Center, and it has a history of judges who have been subject to impeachments. So again, kind of to recap the staffing of the courts, who decides how many people are Supreme Court justices, the process for adding or decreasing, that's purely congressional power. It is up to Congress to make that decision. Now, oftentimes the president has to go along with it because it becomes a law setting the number of Supreme Court justices. But intensively, it is a congressional power with the president signing off. And then judges have a lifetime appointment. Can they be removed? Yes. If so, what does it take and who declares it? It's the impeachment process by Congress. Again, a wholly congressional process.